case briefs, and so much more. LSData's got what you're looking for.
At the heart of the 2009 case, Sassower v. Blumenfeld, heard by the New York Supreme Court, was the question of whether a buyer who failed to go through with a property purchase as agreed must forfeit their deposit, even if the resultant loss to the seller was less than the deposit amount. The roots of the case lay in a property sold by the plaintiffs to the defendant. The defendant, however, did not close the purchase on the agreed-upon date. The terms of the contract between the two parties explicitly stated the seller could retain the deposit if a default occurred. Further stirring the waters, the defendant requested and received an adjournment of the closing, but the agreed deadline again went unmet. In their defense, the defendant pointed to an unexpected loss of personal assets due to the infamous Madoff scandal, arguing it made their compliance with the contract impossible. However, the court weighed the details of the case against the defendant's argument of impossibility for contract adherence. Based on their findings, the plaintiff's motion for summary judgment was granted as a result of the defendant's failure to meet their contractual obligations. As a result, the plaintiffs not only retained the substantial $180,000 down payment, but they were also awarded counsel fees as stipulated in the contract. Meanwhile, the defendant's affirmative defenses and counterclaims were dismissed. The court's judgment underscored that individual hardship does not legally excuse performance of a contract, and that impossibility defenses can only be used in the most extreme of circumstances.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.